Hello, my name is Tom Hartman with the Hartman Law Firm. Life is full of disputes, and when those disputes involve money, that often leads to litigation. In New Jersey, as everywhere in the country, litigation is expensive, unpredictable, and extremely lengthy. It goes on and on with very difficult rules of procedure, rules of evidence. Both sides have attorneys. There are motions, the process goes on and on, it's extended by the court, it involves court appearances and endless amounts of money. There are ways around this, since in New Jersey, for example, 98% of all cases are resolved before they go to trial. These ways around it are often called alternative dispute resolution methods, and the one I want to talk about today is called mediation. And I think it's the most flexible of those available. The reason I say that is that unlike the court system particularly, you control the mediation, whether you're the plaintiff or the defendant. You have a choice in the mediator. In Middlesex County or in Somerset County, the judges often insist that you go to mediation, and they will even appoint a mediator, but they give you the option to say, I don't want to use that mediator, I want to retain my own mediator. I often try to use retired judges. They're familiar with the process, they're familiar with the legal system. They've heard litigation cases for years and years. Now that they're no longer judges, they have a sense of how to resolve these matters before they go through the motion process, the various discovery processes that cost so much money. Not only do you get to pick your mediator, have an option to pick your mediator, who you usually have to pay for, but you also have a much more relaxed environment. Usually it's at the mediator's office, or it can be in an attorney's office. You and your attorney speak privately with the mediator in calm tones. You're not bound by the rules of evidence and the rules of procedure and making motions and objections and all the kind of strictures that are involved in litigation. Those are gone in a mediation, so it's a much calmer environment. You choose the person that you're going to have mediate, and more than that, if at the end of the process you decide that you don't like the settlement, you don't like the resolution, you're not bound by it. So it's a matter of great flexibility. One issue that you should think about is timing. Oftentimes people don't want to try to mediate right away because they think that's a sign of weakness. And yes, there's an element of factuality and truth to that in this. You want to make sure that you've got the documents and that you know as much evidence and information as you can before you go to the mediation conference. Because that way somebody won't say, well, I would settle if I had this information. Get all the reasonable information on the table. Not every last stitch of evidence that would be required in litigation, but the majority of the evidence. Get the strengths of your cases assembled and know your weaknesses, and then go to the mediation and see if you can resolve it short of the lengthy, complex, and expensive process of mediation. And if you need assistance with this, the Hartman Law Firm is always available both for mediation and to help you through the litigation process, which is the focus of this firm. Thank you and good day.